promotion, item number 1.
Seek Lordship indulgence. Lordship, part 2, item number 2. Though it is Lordship, this matter is fixed for today. Lordship, however, from the reading of the paper book, some of the documents which I have annexed in the memo of the appeal is not available in the paper book, Lordship. But however, it is in the appeal memo, Lordship. Whether, if it is
paper book, yes. That is what my lord. Just a moment.
Yes.
Obliged.
Item number 1.
Your Lordship, I'm appearing on behalf of Lai Autonomous District Council, Arlen Musiama. Your Lordship, my Lord, can the matter be taken up for tomorrow because the leading counsel appearing in...
My Lord,
Yes, I accept.
So let's see what is the matter about, whether it deserves for a notice to be issued or not.
so my Lord, this is another case where a village council in the LADC has been suspended, my Lord. Now, this is a village council of Sangawan, my Lord. Now, what we are challenging, my Lord, is at page number 101. This is the first notification. No, actually, my Lord, if your Lordship will turn to page number 90, page number 100. It says like this, my Lord. In pursuant of a complaint from Lian Kamlova, President, and Sangyapa, Secretary MNF Sangawan, pertaining to Sangawan Village Council's manner of work and their use of funds, an inquiry commission is established on dated 6th November 2025 upon Sangawan Village Council as per notification number so-and-so by the authority granted under LADC VC Act 2010, Chapter 2, Section 10(1) as amended from time to time, and from this day onwards, the Executive Committee hereby suspends Sangawan Village Council by the authority granted under LADC VC Act 2010, Chapter 2, Section 1, amended from time to time. Further, the following person is hereby appointed as an inquiry commission. The inquiry commission shall, after consideration and scrutiny of the facts observed and known to it, and after investigating the same, shall submit a report to be undersigned before the expiry of 3 months. If the report cannot be submitted within 3 months, an extension of 1 month shall be granted. Now, this is the first notification we are challenging.
Suspended.
Suspension. And the second notification, my Lord, is at page number 102. Page number 103, my Lord, is the English translation. In pursuance of a complaint from the Kamlova, President, and Sangyapa, Secretary, my Lord, these names are important. Pertaining to Sangawan Village Council, so-and-so, my Lord, that has been, I will not read, but if your Lordship will come down to the below, second paragraph. Further, during the period of suspension, The Executive Committee Lai Autonomous District Council, by the authority granted under LADC BC Act 2010, Chapter 2, Section so and so, hereby appoints the following 3 persons as caretakers to manage the affairs administration of the village. Now, the first person, my lord, is the present president. The original president, who was the president of the village council before the suspension. F. Rosewala, my lord.
So,
And these two, Lian Kamlova and F. Sangyapa, my lord, they are the complainants.
no, come again regarding the serial number 1, F. Rosewala. He's the
Actual village council president.
okay, but with the suspension of the village council, he is the acting now.
Now
Is it?
he has been appointed as the acting VCP, my lord. That's the first. And these two people, my lord, they are the two complainants.
Okay.
Now,
Will
what we
issue
are saying,
notice,
will issue, and my lord, these two notifications, my lord, were issued on the same day the complaint was submitted. Complaint was submitted on
Where's the
6th.
complaint?
My lord, the complaint is not given to us, but it's mentioned in our writ petition, my lord. The complaint till today has not been given to us. No show cause notice has been issued to us. On the same day, these two notifications were issued. So the humble submission that we have, my lord, at present is, my lord, at least with respect to the extent of the caretakers, my lord must remember the order passed before. Similar order, my lord had passed one order, a similar case, where where the responsibility of the present members, my lord, I mean before the suspension, my lord, your lordship had passed an order saying that those people should continue to be allowed to continue to function.
Supposing we are allowed to continue, then the acting VC will be the same.
The same.
He'll continue.
Only the members will be different.
Because if you're saying he's the same person, then he'll continue.
Correct, correct.
Anyways, we'll issue notice. Let's see. Heard Mr. Joseph L. Brindley, Learned Counsel for the petitioner, who has filed the instant writ petition under Article 226 of the Constitution of India, assailing the notifications
Dated 6.
dated
06/11/2025.
06/11/2025 and same
Yes.
the notifications dated 06 so and so, wherein the village council Sangha 1 has been suspended, and thereafter in the second notification dated 06/11/2025, the respondent number
Respondent numbers,
F. Lal Rosewala will be respondent number.
I'll check, my lord. Respondent numbers 4 to 6.
F. Lal Rosewala will be respondent number
4.
4, wherein the respondent number 4, who is the present VCP before the suspension, was made the acting VCP along with respondent number 5, is it?
Yes.
And respondent number 7
Six.
as respondent number 6
Yes.
as the caretakers during the suspension period, which is for a period of 3 months, extendable by
1 month.
to 1 month. Okay, full stop.
My lord, 5 and 6, my lord, not caretakers, member caretakers.
Okay, member caretakers. Okay. The Learned Counsel submits that the imputed notifications are liable to be set aside since the notifications were made on the same day a complaint was filed by the respondents number
5 and 6.
5 and 6 without issuance of any show cause notice to the members of the to the petitioners. Okay, let's stop. Then issue notice of motion to the respondents. Miss Lalrin Swali accepts notice on behalf of the respondents
Number 1 to
number 1 to 3, is it? Number what, 1 to 3. Notice be issued to the private respondents number 4 to 6 through registered post with AD within 3 working days, returnable by 3 weeks. List the matter after 3 weeks. Full stop. New para, the learned counsel for the petitioner has further prayed for the suspension of the said impugned orders till the next date of listing. Not till next date, till the disposal of the instant writ petition. Since the said impugned orders were issued without issuance of any notice and clearly in violation of what?
In violation of, my lord, the principles of natural justice
Principles of natural justice and must
and
be
the,
some.
and the Lie Autonomous District Council.
Okay,
Village
and
Council.
the LADC within brackets, Village Councils, close bracket, Act,
2010.
comma, 2010.
10.
Full stop. Having heard the submissions made by the learned counsel for the petitioner, this court find it fit to state the operation of the impugned orders till the next date of listing. Yes.
Much obliged, my lord.
Item number 2.
My Lord, I have been recently engaged to represent item number 2 to 18. My Lord, these are analogous matters. My Lord. I have been engaged for the NHIDCL.
Wait, in writ petition 31? You're
31
engaged in
is
writ
item
petition 31, is it?
30, yes. 2 is 31. These are all analogous matter
Okay, 2 and,
up to 18. 2 up to 18.
okay, all this thing, 2 to 18.
These are all, Lordship, these are all analogous matter. My Lord, it pertains to either, my Lord, claim for the less amount of compensation receipt or non-receipt of the rehabilitation and resettlement grant,
Okay,
etc.
anyways, you are going to represent which,
NHIDCL in all these matters.
you're going to represent whom? The petitioner or the respondent?
Respondent NHIDCL, my Lord, will.
Okay, NHIDCL, is it?
NHIDCL.
I thought Mr. Samuel used to represent NHIDCL.
I'll be, my
Be
Lord,
appearing on
leading, my
the
Lord.
hearing part, my lord.
Okay, for the hearing.
Yes, ma'am.
So you will be there
be-
for the
I'll-
hearing of the matter, is it?
I'll be leading Samuel, my Lord. He'll be there. My Lord.
Okay. Anyway, so what is the stage now?
But I have to verify, in fact, there's.
Have you all
still numbers-
filed your written objections?
That need to be, my Lord, verified whether, my Lord, the affidavits have been
case by
filed
case
or
we'll have
whether
to
any
see.
additional is required. As I have been recently engaged, my Lord, I seek.
Counters
certain
already
time-
filed. No, not yet filed. Respondents have not filed their counter in WPC 31, item number 2. Who are the respondents? You are the respondent,
Yes, yes.
so you have yet to file your counter?
Lordship, my Lord, in some cases we have filed,
Okay.
in some cases we
Some
have
not.
not, so it
So
need
we'll
to be
have to see
verified.
case by case, isn't it? Yes,
my
so
lord,
in item
my lord,
number
I-
2, it appears that counter has not been filed.
My lord,
So we'll give you
My Lord,
time.
may I pray one thing, my Lord? I am seeking,
Comment
my Lord,
counter.
some accommodation in these matters. In the meantime, my Lord, we'll verify wherever, my Lord, affidavit has not been filed
Okay.
and required to be filed, we'll file it, my Lord.
So
Or
all the
any
matters,
additional affidavit
yes,
is
okay,
required, then
all the
also we'll
matters. The petitioners are present, isn't it? Mr. Zoram Chana, learned counsel for the petitioner is present along with Mr. Samuel Vanlal Shiata, learned standing counsel for NHIDCL, and Mr. so-and-so, your good name, I can't see, so-and-so, learned counsel, who submits that he has been recently appointed to also represent the NHIDCL in the instant case, full stop. Mr. So-and-so, learned counsel submits that he may be given time,
Just 4 weeks' time, my Lord.
okay, given 4 weeks' time.
my lord,
Your Lordships, this pertains to, my Lords, rehabilitation and resettlement award. These petitioners, my Lords, they've been waiting for some time, and these petitions have been filed, my Lords, last year, most of them.
Let
My Lords,
him
4
this
weeks would
thing.
be a stretch. My Lords may keep it for after 2 weeks.
Can you make it 3 weeks? has prayed for 3 weeks' time. We'll make it 3 weeks.
Lordship.
Because Mr. Samuel is already there, you can consult each other, isn't it?
Lordship.
Has prayed for 3 weeks' time to file the counter affidavits, if so required, in some of the writ petitions
My lords, if this could be a last opportunity.
who have, which being analogous matters.
And my lord, any pleadings required to be filed or affidavit may be filed during these 3 weeks, my lord.
Okay, list after 3 weeks, by which time all the necessary counter affidavits are to be filed. Yes.
May I pray for a date, my lord, a fixed
Okay,
date, my
after
lord, so
3
that it
weeks
becomes
on,
continuous.
give a date.
3 weeks. 10, continue, I don't know.
When do you want it? You give a
December.
date. 10th?
My lord, 5th of January or 19th of January?
5th of
19th.
January is holiday, my
That
lord.
will be more than, no, it's all a holiday.
Your Lordships may grant the last,
5th
second
January.
last day of the working day of December.
Try and make it on the, if it's after 3
11th,
weeks, list after 3 weeks on, January, the moment it opens.
Lodge.
On,
15th.
yes. Okay, we'll make it on the 14th. On 14/1/2026, yes.
Oblige, my lord.
Oblige.
So 1 to 18 done, all analogous.
Item number 19.
Your Lordship, I seek indulgence. In this case, some criminal case is there. That's why it's adjourned for 2 weeks. I'll check it.
19, item number 19.
Yes.
You're for the petitioner.
I'm for the petitioners.
How come your
The
name
thing
is not
is
there?
that there's alleging that it's the pass of some of the petitioner pass, land pass is not genuine. So
We'll just
special
make
court-
it the learned counsels for both the parties.
My
You
lord,
have prayed for what?
as per the last court order, my lord, the direction has been given to the state.
You were supposed to file an impleachment application. Are we on the
Yes,
same page?
this
See,
one also, I'll see to that, Your Lordship, there's some new come up, that's why.
So you're supposed to file an impleachment application also.
Yes, I'll
And
check
your
it
name is not reflected in the cost list. How come? Item number 19. Writ petition 90. Anyways,
90.
how come your name is not reflected? You would be the,
I don't know, why, it's happened so many times.
anyways, Ms. Dinari El-Lazu, learned counsel for the petitioner, is present and has prayed for adjournment of the matter due to certain recent developments in the case. Good stuff. It is also seen that the name of Ms. Dinari El-Lazu, learned counsel, is not reflected in the cause list. The registry to reflect the name of the learned counsel for the petitioner in the cause list, as prayed for by the parties, list the matter after 3 weeks.
Much appreciated.
Item number 20.
My lord, the present matter pertains to claiming of back wages. So since last year, November, the state respondents had sought time to submit their affidavit.
Yes, where's the, no one represent the state? Anyways, in the last court date, you had not appeared. Mr. F.L. Liana, learned counsel for the petitioner, is present, while none appeared for the state respondents.
My
In
lord,
view of the above, list the matter of the
My
3
lord,
weeks. Meanwhile,
that regard-
yes.
I'd like to make a prayer that
Oh.
lessons will be given because it came already more than a year since
while
filing
none
of the
appeared,
present.
while none appeared for the state respondents, full stop. The learned counsel for the petitioner submits that this matter has been pending for over a year, awaiting for the counter affidavit to be filed by the state respondents. He prayed that a last chance may be given to the state respondents. Let me just see whether, how many times. In view of the submission made by the learned counsel for the petitioner, the state respondents are to file their counter affidavit positively by the next court date, failing which this court will pass the appropriate orders. Yes.
Obliged.
Yes, now we had noted that none appeared for the state respondents. Are you going to appear on behalf of the, being a government advocate? It might not look nice, isn't it? Anyway, so we'll make it Miss Vani Siami. Learned government advocate has prayed for further time to file their counter affidavit. Okay. Ms. Lal Nunlu had appeared in the last court date, item number 19.
Yes, Your
So we are giving you another chance, failing which we'll have to pass an appropriate order. Matter has been pending for over a year, awaiting for you to file your counter affidavit.
Understood, Your Lordship.
Take a note of the case.
Item number 21.
Lordship, as per this office note dated 18/11/2025, a card upon respondent number 1 has not been returned yet. But however, Lordship, in
Who is
the
respondent number 1?
respondent number is 1, Lordship, that is Balaji Developers. We have served notice upon the proprietor, through the proprietor.
Recently, it's only last month, so we'll
Yes.
wait for some time.
Yes, Lordship.
Isn't it?
Moreover, in the civil suit that is pending before the civil judge, senior division, the matter has been referred for mediation. So
Okay,
we can
so
await-
we-
yes, we
So
can
you
wait for that.
will adjourn the matter, see the outcome, isn't it?
Yes, yes.
Ms. Manswamy, H. Manswamy, learned counsel for the petitioner is present, along with Ms. Vani Siami, learned government advocate for the state respondents. Full stop. The learned counsel for the petitioner has prayed for adjournment of the matter by
Lordship,
submitting.
Not adjournment, await service report and.
Okay, has prayed that a service report upon the respondent number
Number
1 may be awaited. In view of the above, list after 3 weeks.
Item number 22.
Yes,
Please, Your Lordship. My lords, the records of civil suit number 4 of 2022 is not yet received, my lord. And only the records of RFA 12 of 24.
so we have called for TCR, isn't it?
Yes, yes, my lord.
So TCR not arrived?
Yes.
Okay, then we'll wait for the TCR. When was it called for? From which court?
From Mamit, my lord.
Mamit, so it may take some time, isn't it? Do we, okay, Mr. Lalbiak Nunga Namte, learned counsel for the appellant is present, along with Mr. So-and-so, learned counsel for the respondent, is it?
Yes.
R.K. Manswamy for the respondent, full stop. It is seen that TCR called for from the learned trial court has not been received till date. In view of the work, I think we'll issue a reminder.
Yes.
Okay, issue reminder to the learned trial court, list after 3 weeks.
Deeply obliged, my lord.
For orders, item number 23.
Yes, Your Lordship. In the last week, I was submitted
that the money have to be deposited before the commissioner. And Your Lordship, it has been submitted, deposited, and the receipt is in the main appeal. In the main appeal, page 13.
Okay, so what is the IE about? Condonation of
Condonation of delay, Your Lordship, 353 days.
So where is the receipt in the main appeal?
Main appeal, page number 13, 1-3.
You didn't see it in the in the previous court date, is it?
Yes, Your Lordship.
Hmm, 20 lakhs, so and so. Okay. So, what is the reason for your delay?
Yes, Your Lordship, the reason for delay is that due
How
to
many days?
353 days.
Almost a year. Where is it explained?
It is explained in page number 3.
Okay.
starting
Give a
from-
gist of the reasons, sir. The first
Yes,
one
Your
is,
Lordship. The judgment and order was received on 18/10/2023, and later on a copy of the judgment and order was received by the department on 30/10/2023. And thereafter, Your Lordship, the department had sent a letter to the additional Advocate General to prefer an appeal, that is on 9/11/2023.
So decision to file an appeal was taken on 9/11.
9/11. And later on, in the same date, on 9/11, the matter was endorsed to the learned government advocate.
Okay.
And after the learned government advocate received that endorsement, she sent a letter for providing documents and as well as necessary things to do for depositing the amount. And in this regard, Your Lordship, in order to deposit the amount, it is the state government, so they have to go through several procedures. And it has to go to the finance department for approval, and again, it has to go back to the concerned department. So it takes time, Your Lordship. And altogether, the government advocate received the required document on 3/4/2024. That is on 3/4/2024. And after receiving that, the government advocate had prepared the appeal.
So
and
that's after how many months?
that is after December, January, February.
After taking a
March.
decision.
After 3 months.
Oh.
After
Okay.
3 months.
Oh.
And after getting ready the appeal memo, Your Lordship, again, the government advocate had to apply for court fees.
How long does it take? 1 day?
No, Your Lordship, in order to receive that court fee, again, it has to get approval to deposit the requested court fee.
How much is the court fees?
10,000.
Not such a huge amount, isn't it? So what did it do? Where
And
did it
after
go?
after receiving the court fee, the government advocate received the court fee on 13/6/2024.
Who did it approach for the court fee?
Home Department. To the Home
So
Department.
when did it approach the Home Department? We have to see whether there's negligence on the part of the Home Department, isn't it?
Yes, Your Lordship.
With 10,000. So where's the letter? Home Department, where did it send?
A letter was sent on 13 June 2024.
Send letter to Home Department on 13 June.
And the court fee was received on 12/8/2024.
So why this delay? Applying for court fees only on 13/6/2024?
As already mentioned, Your Lordship, in order to receive that amount, this amount, it has to go.
Okay, when was
follow-
it received the amount?
It was received on the month of August, 13 August.
29 lakhs. Is it?
No,
What amount?
that is for the court fee, 10,000. The amount which we have, the 20 lakhs is
So
for
how
the
many months
deposit.
did it take to receive 10,000?
2 months.
So you're not taking it seriously, isn't it? The department.
And later on, Your Lordship, the government advocate has to take, unfortunately, maternity leave. That is from 1/7 to 2024 to 30/9 2024. She is on leave.
Where's
And,
that? Where's that?
her leave record is at page,
No, but in para what in your petition application?
the application is not there, but the cost list is there.
No, in your application here for the reasons. Okay, maternity leave.
Yes.
This is at page 7, is it?
Yes, Your Lordship.
Then?
And after joining her office again, her baby got sick.
How many government advocates are there? So why wasn't
At
this
this
given
present
to
of
someone
time,
else?
Your Lordship, during this time, there are only 2 additional advocate general, since the 2 government advocate has taken leave for maternity leave.
All of you have taken maternity leave.
No,
is
at the
it?
time, I am not the government advocate, Your Lordship.
This is
So
in
there is only 2
2024.
government advocate. Yes, Your Lordship. There is only 2 government advocates
Okay.
and 2 government advocate additional advocate general. So the 2 government advocate has taken leave during this time.
So there was only one.
There is only one. Your Lordship.
Okay.
And since her baby got sick, and the appeal cannot be moved, and later on the month of December 2024, the appeal memo was registered. So by looking at the dates and how the letter has been sent, Your Lordship, there is no negligence on the part of the concerned department as well as the government advocate. The departments and the government advocates are always in due diligence to prefer an appeal, Your Lordship.
Why do you want to appeal?
The reason why we want to appeal is that, Your Lordship, the learned trial court fails to consider the evidence produced by the respondent, by the defendant.
No, what is the matter about anyways?
The matter about is that one person who is a driver met an accident, and they were claiming compensation of that. And
He died or what?
at the
Did he
time
die
of the
in the
accident,
accident?
the vehicle which he has drove is not a government vehicle. It is a private vehicle.
But is he employed by the... He is
Yes,
employed,
Your
isn't
Lordship,
it?
he was employed. But since it is not his duty time, the time of the accident, by looking at the time of the accident, Your Lordship, that is beyond his duty routine. So unfortunately, he met that accident.
But it appears that he was returning from his workplace, isn't it? So was he on duty at Kozol? Here, I've just looked at this thing. So he's gone for his duty, and coming back from his duty, he met with an accident. Or else, how was he supposed to come back? Anyways, we'll have a look at that later.
Yes, Your Lordship.
Whether you have a case or not. Yes.
And Your Lordship, I would like to submit 2 citations in this regard.
Yes.
(2005)
2005.
1 SCC 625.
2025 or 2005?
2025.
Para?
Para 20.
20?
Yes, from the 7th line, Your
What does
Lordship.
it say?
It is not the length of delay that would be required to be considered while examining the plea for continuation of delay. It is the cause for delay which has been propounded will have to be examined. if the cause for delay would fall within the four corners of sufficient cause, irrespective of the length of delay, some deserve to be condoned. Same deserve to be condoned. However, if the cause shown is insufficient,
So you're saying
irrespective-
yours is sufficient cause? is
Yes,
it?
Your Lordship.
Hmm.
And another
else?
citation, that is 2005, 3 SCC 7752,
Para?
para 14.
Yes.
If I may read out, Your Lordship. In G. Ramegoda versus Special Land Acquisition Officer, it was held that no general principle saving the party from all mistakes of its counsels could be laid. The expression sufficient cause must receive a liberal construction so as to advance substantial justice, and generally delays in preferring the appeals are required to be condoned in the interest of justice.
Para 14, you've already got it, but you fiddle. Huh?
Where no gross
leave it like that.
negligence or deliberate inaction are lacked of bona fides inimputable to the party seeking condonation of the delay. In litigation to which government is a party, there is yet another aspect which perhaps cannot be ignored. If appeal brought by government are lost for such defaults, no person is individually affected, but what, in the ultimate analysis, suffers is public interest. The decisions of government are collective and institutional decision and do not share the characteristic of decisions of private individuals. The
But
law,
this is private, there's no public interest is concerned here, isn't it? Anyways.
the law of limitation is no doubt the same for the private citizens as for governmental authorities. Government, like any other litigant, must take responsibility for the acts omissions of its officer. But a somewhat different complexion is imparted to the matter where government makes out a case where public interest was shown to have suffered owing to act of fraud or bad faith on the part of its officer or agents, and where the officers were clearly at cross purposes with it. It was therefore held that in assessing what constitutes sufficient cause for purpose of Section 5, it might perhaps be somewhat unrealistic to exclude from the consideration that go into the judicial verdict these factors which are peculiar to and characteristic of the functioning of the government. Government decisions are proverbially so encumbered as they are by a considerable degree of procedural red tape in the process of their making. A certain amount of latitude is therefore not impermissible. It is rightly said that those who bear responsibility of government must have a little play at the joints. Due recognition of this limitation or governmental functioning, of course, within reasonable limits, it is necessary if the judicial approach is not to be rendered unrealistic. It would perhaps be unfair and unrealistic to put government and private on the same footing in all respect in such matters. Implicit in the very nature of governmental functioning is procedural delay incidental to the decision-making process. The delay of over 1 year was accordingly condoned. So, Your Lordship, here it is stating that the government and the individual persons should not be treated
Okay.
equally. As the reason for delay has been explained, accompanied by a document, Your Lordship. And my humble submission is to condone the delay of 353 days in order to...
353 days.
Yeah,
Almost
yes, Your
1
Lordship.
year. Okay. Yes.
May please, Lordship. Lordship, yes, my learned friend had read out that the initial appointment for filing an appeal was taken by the government on 9/11/2023. Lordship, 9/11/2023, which is annexure 2 of their application, Your Lordship. 2 of their application addressed to the Additional Advocate General, Lordship. And the court fees was supplied on Lordship 12/8/2024, which is 279 days. After making a decision by the government, court fees was supplied on 12/8/2024, which is 279 days, which is left unexplained, Your Lordship. And besides that, Your Lordship, I have filed my objection. There are so many unexplained delay in between, Your Lordship. May I take Lordship to my affidavit in opposition? Page 4, start from paragraph number 5.
Yes.
May I read, Lordship?
Yes.
With regards that regarding paragraph number 1 of this application, the applicants did not provide any explanation for 13 days delay in receiving the judgment and order dated 18/10/2023, which they claim to receive only on 30/10/2023, that is 13 days after the judgment was issued. In contrast, the responding opposite parties received the judgment and order on the same day it was pronounced, that is on 18/10/2023. Hence, the applicant's failure to account for this 13 days delay in their application renders it liable for rejection. Moreover, another 11 days counting from 30/10/2023 to 09/11/2023 were left unexplained, which clearly shows that the matter was not pursued diligently by the applicants. Hence, this application is liable to reject it. At this stage, Your Lordship, the applicant just simply annexed the impugned judgment and order. There is nothing to show that this particular judgment and order was received on 30/10/2023, Your Lordship. There is no signature, there is no date at all. So they just simply say that it was received on 30/10/2023. And the next paragraph is that with regards to paragraph number 1, 2 of the application, the applicant herein again failed to explain 7 days delay counting from 9/11/2023 to 16/11/2023. In fact, no attempt has been made by the applicant for such 7 days delay. Hence, failure to address or justify the delay indicates procedural negligence, and as such, this application does not contain any sufficient explanation, and hence this application is liable to be rejected. That the averments made in paragraph number 1.3 and paragraph number 1.4 of this application are strongly denied. In fact, the applicant asserted that the concerned department, Home Department, Government of Mizoram, received the government advocate's letter dated such and such only on 5/12/2023. However, this claim cannot be accepted without documentary evidence confirming that this letter were indeed received on 5/12/2023. Consequently, the 20 days delay from 16/11/2023 to 8/12/2023 remains unexplained. The appellants had ample time to acquire the necessary documents and file a timely appeal. Moreover, the government's advocate's letter 16/11/2023 and 20/11/2023 clearly outlined the required documents and the appeal period before this honorable court. The applicant's inaction and failure to expedite the process or seek timely legal remedies are unacceptable. Moreover, relying on administrative delays cannot be a valid reason for condoning the delay, as it is the state's duty to ensure the timely filing of the appeal before this honorable court. The appellant's lapse and failure to exercise due diligence demonstrate negligence, which should not be excused. Therefore, this application is liable to be rejected. That with regards to paragraph number 1.5 of this application, it is submitted that the applicants have once again failed to account for additional delay of 38 days counting from 8/12/2023 to 15/01/2024 for getting approval for payment of compensation to the answering opposite parties. Consequently, the instant application is liable to be rejected. That with regards to paragraph number 1.4, it is submitted that the applicant again failed to explain 15 days between 15/1/2024 to 31/2024. Additionally, no explanation for another 16 days delay counting from 31/2024 to 15/2/2024 were given in this application. As such, this application is liable to be rejected. That with regards to paragraph number 1.7, it is submitted here that the concerned department forwarded the approval letter dated 15/2/2024 to the government advocate. 28 days later, on 14/3/2024, the government advocate sent a letter back to the concerned department requesting the necessary documents. This resulted in an unnecessary delay of 28 days without any explanation. as seen in the Annexure 2 of this application, the applicant had already decided to file an appeal and had communicated with the Additional Advocate General to take immediate action for filing an appeal on 09/11/2023. However, on 14/03/2024, after a lapse of 127 days, the government advocate's request for required documents from the department demonstrates nothing but gross negligence on the applicant's part. Furthermore, it is noted that the government advocate sent a letter dated 14/3/2024 to Undersecretary Home Department regarding the
So
connected
wait, when
case.
did the government advocate requested for the documents?
Documents was Yes. Still not so.
Yes, Your Lordship, in that regard, on 16 November, the government advocate sent a letter to the Secretary, Under Secretary,
2024, is it?
16 November 2022.
Okay, where's that?
And that is in IA, page number 34.
Okay, sent. So they took so
And-
much time.
And after that, the department had sent a document. But however, the document was not completed. And again, the government advocate asked for additional documents.
Okay, yes.
Also, it may take to paragraph number 6. No. Also, paragraph number
10.
10.
We are
Also,
reading
yes,
10.
yes. Reading 10. That with regards to regarding para 1(7), it is submitted here that the concerned department forwarded the approval letter dated 15/2/2024 to the government advocate. 28 days later, on 14/3/2024, the government advocate sent a letter back to the concerned department requesting the necessary documents. This resulted in an unnecessary delay of 28 days without any explanation. As seen in Annexure 2 of this application, the applicant had already decided to file an appeal and had communicated with the Additional Advocate General to take immediate action for filing an appeal on 9/11/2023. However, on 14/03/2024, after a lapse of 127 days, the government advocate's request for the required documents from the department demonstrate nothing but gross negligence on the applicant's part. Furthermore, it is noted that the government advocate sent a letter dated 14/3/2024 to the Undersecretary Home Department regarding the connected case. Yet, after a delay of 6 days on 20/03/2024, the Undersecretary Home Department forwarded a letter dated such and such to the DGP Mizoram, which remains unexplained. Consequently, the application is liable to be rejected. That with regards to para 1(8) of this application, the applicant submitted that the government advocate received certified true copy of the judgment and order along with original certificate receipt of the compensation amount to the Commissioner Employees Compensation, Aizawl, Mizoram, on 03/2024. However, 15 days have passed without any explanation from the department regarding this delay. Lordship, here the initial decision was made on 9/11/2023 and certified copy was applied on 03/4/2024, Lordship. And that with regards to paragraph number 1(9), the counsel for the applicant submitted that regarding drafting of the instant appeal commenced immediately after receiving necessary documents on 03/4/2024. However, in para number 110, the applicants further stated that appeal was intended to be filed in June 2024, indicating that the counsel for the applicants took approximately 88 days to draft the appeal, counting from 03/4/2024 to 0/30/6/2024, which was not adequately explained. Additionally, there was no explanation as to why the required court fees were not supplied to the counsel for the applicants by June 2024, since the applicant had already decided to file an appeal as early as 9/11/2023. It is also noted that via letter 13/6/2024, the government advocate requested the concerned department to provide requisite court fees, which was 218 days after the initial decision, counting from 9/11/2023 to 13/06/2024 for filing an appeal before discernible court by the concerned department. Furthermore, the required court fees were supplied to the government advocate on 12/8/2024, which was again 61 days, counting from the letter 13/06/2023 sent by the council for the applicants for supply of the court fees. In fact, nowhere in the application does not explain why the required court fees were given to the council for the applicants after a delay of 61 days. Consequently, the applicant failed to provide necessary explanation for the above-mentioned excessive delay, which amounts to laches and negligence, rendering the application liable to be rejected. That with regards to para number 1, 9, 11, 12, and 13 of the application, it is submitted that although the counsel for the applicants was on maternity leave from 1/2024 to September 30, 2024, this does not constitute a reasonable excuse for the inability to process with this appeal. Other government advocates are available before discernible court to handle the matter. Furthermore, although the government advocate resumed her duties in the month of October 2024, appeal was not filed till 5/12/2024, Lordship. In this context, the counsel for the applicants attached two medical OPD cards dated 31/2024 and November 16, 2024, but provided no further explanation for another 64 days delay. More precisely, the delay of 64 days is not counted for anywhere in this application. Hence, this application is liable to be rejected. That the statement made in 2, 3, and 4 are strongly objected. It is submitted that the applicant failed to explain. Yes.
So, any citations
Yes, Lordship.
to depend on?
2013 4 SCC 52, paragraph number 9, Lordship. It is.
What does it say?
Lordship, may I read?
Yes.
We have heard the counsel, the learned counsel appearing for the applicant and the learned counsel appearing for the respondent state. There is no dispute that the expression sufficient cause should be considered with pragmatism in justice-oriented approach rather than the technical detection of sufficient cause for explaining every day's delay. However, it is equally well settled that the courts above liberally consider the prayer for condonation of delay, but in some cases, the court may refuse to condone the delay inasmuch as the government is not acted to keep watch whether the contesting respondent further put the matter in motion. The delay in official business required its pedantic approach from public justice perspective. In a recent decision in such and such, the matter came up against the order passed by the High Court condoning the delay in filing the appeal by the appellant Union of India. The High Court refused to condone the delay on the ground that the appellant Union of India took their own sweet time to reach the conclusion whether their judgment should be appealed or not. The High Court also expressed its anguish and distress with the way that the state conduct the case regularly in filing the appeal after the same became operational and barred by limitation. Lordship, at paragraph number 10, third line from the bottom, Your Lordship. Merely because the respondent is a state, delay in filing an appeal or revision cannot and shall not be mechanically considered, and in the absence of sufficient cause, delay shall not be condoned.
Okay.
Lordship,
That's it.
other citation passed by the coordinate bench of this Honorable Court. Lordship, this IA number 134 of 2024, operative is from page 11, paragraph number 12. Page 11, paragraph number 12.
Yes.
May I read, Lordship? Yes.
Yes.
Coming to the present case, as already noticed, there is no explanation as what had transpired between 11/9/2023 to 07/12/2023, 14/12/2023 to 29/4/2024. It is a settled law that length of delay ordinarily should not matter if there are proper explanations with sufficient cause rendered by the applicants concerned. Tendering of day-to-day explanation may not be insisted, but then there has to be some explanation. In fact, reasonable explanations with supporting materials to show that the matter had been pursued diligently and with a bona fide intent. There is, however, no explanation in the instant case, importantly for the aforesaid period, besides the other shorter periods. The case such and such is relied upon by the learned government advocate, but it may be noted that the delay in the case was for 57 days, and the explanation for the state appellant that the file had moved from table to table and was misplaced at some stage was accepted by the Apex Court. However, in the instant case, there is no explanation for certain period of time. It is true that sufficient cause as it should be considered with pragmatism and justice-oriented approach, rather than technical detection of sufficient cause for explaining every day's delay, as opined in the Apex Court in such and such. But then such discretion can be exercised when the explanation for the delay is tendered, whatever it may be, for the consideration of the court. Unfortunately, here is a case no explanation is given for a period of such and such, amongst others. The Apex Court in such and such held that the party should not have acted. No, next is, Your Lordship. It's passed by Your Lordship. Paragraph numbers Lordship 6, 7, and 8 is there relevant. Having considered the submissions made by the learned counsel for both the parties, this court has noted that the applicants has received a copy of the impugned judgment and award dated on, and a legal opinion for filing was also received by the branch manager insurance company on. However, the matter was kept pending for 616 days. Here in our case, Your Lordship, total number of the delay counting from the judgment is 413 days, Your Lordship. The explanation given by the learned counsel for the applicant appears to be due to the fact that even though the applicant was aware of the judgment and award and advised for filing appeal, no prompt action, and the matter was delayed for exchanging correspondence between Legal Help Regional Office Guwahati and Divisional Office Silchar.
Okay.
Lordship, in our case, government and the Lordship. And lastly, Your Lordship, this is a driver by a profession under the Mizoram Police, posted at 2nd IR Battalion, this Khozol, Your Lordship. And the respondent number 1 is the wife, and 2, 3, 4 are the daughter and sons of the deceased, Your Lordship. So the deceased is the sole bread earner, and it is clear that at the time when he coming back from his office, accident was occurred, Your Lordship. So there is no reasons to allow this application, Lordship.
Okay. Yes. But Ms. Vani Syami, learned government advocate for the state respondents, also heard Mr. Johnny L. Tochi, learned counsel for the opposite party, a matter reserved for order. Yes.
Obliged.
Item number 24.
My Lord, I'll be appearing for respondent number 1 and will be filing our Wakalatnama during the course of the day.
None appeared for the applicant, while Mr. Ram Murmur, is it?
Yes.
Learned counsel submits that he will be representing respondent number 1 and will be filing his power within the course of the day. In view of the above, list after 2 weeks.
Bless.
2 weeks during which the learned counsel for the respondent may file their written objection, if any.
Item number 25.
My Lord, this is a case relating to Sirkatu Baga Road compensation. Just 2 days back, Your Lordship has passed an order disposing the condonation application, my Lord. Here in this case, we have filed compliance of justice service on 10/10/25. However, the
So, what, we allowed the matter to be condoned?
yes, my Lord,
Oh,
where
okay.
the affidavit for justice service has been complied.
Hmm.
May I place the order passed by Your Lordship, my Lord?
So today is for the main, today will be for the main LA appeal, isn't it? In this matter, condone.
If this is condoned,
So in the main LA, so we'll go to the main LA.
No.
If condonation was allowed.
yes, my
isn't
Lord,
it?
it has to be condoned.
Heard Mr. Seal Al-Fagzola, learned counsel for the appellant. It is seen that this court has disposed of the IA number
No, in a related matter, my Lord.
in the related matter.
Yes.
So now the IA is not condoned here.
Not yet, not in this case.
Okay. Then we'll have to wait.
No, the affidavit for Dusty has been complied and they have to refuse to acknowledge that. In a similar matter, Your Lordship has disposed.
Who is this thing? The respondents, state government.
1 and 2. Now,
Government, they have to be here at least.
in the previous court date, Your Lordship has struck off the government respondent.
Okay, in this.
Yes, just like that. In the other case also, we wrongly implemented the department.
So
Revenue
in this case, have they been struck off?
not
yet.
They are yet to struck off.
So we'll pass that order at
Yes,
least,
my lord.
isn't it?
My lord.
Yes, Mr. Seal Al-Fagzola, learned counsel for the applicant is present and submits that notice has been duly served upon the private respondents number 1 and 2 and through dusty mode. And is the affidavit there?
Yes, ma'am.
Affidavit to that effect has been duly filed, wherein the private respondents, they have refused, is it?
Yes, they are not
Refused
willing to be.
accept the notice. Full stop. The learned counsel further submits that the names of state respondents number 3 and 4 may be struck off since the present applicant is the PWD department, okay, being a department of the state, and that the respondents number 3 and 4 have been implemented mistakenly. In view of the above, then respondents number 3 and 4 are to be struck off, registry to do the needful. Full stop. Then it is seen that the instant case, the instant application is for the condonation of a delay of 140
40
days.
days.
Let's see the order. Survey. And the learned counsel for the applicant submits that the delay has been explained in detail at paras what
3 subclause 1 to 25, Roman 25.
a subclause, it will be Roman small, okay, 1 to 25. The main reason being that the department slash applicants had to consult and get the legal opinion of the government advocate regarding the filing of the appeal against the order against the judgment and award, okay, instead of order, judgment and award dated 17/12/2024, passed by the learned Judge Colosseum. It'll be learned what judge?
Yes, ma'am.
Colosseum District in LA case 15 of 2015. So, time was also taken to procure the required documents and thereafter to prepare the appeal memo. So, he also the learned counsel also submitted that further delay was also caused due to the closure of the High Court during the winter vacations. The new para, this court has perused the explanation given, this court has considered the explanation given by the learned counsel and has also perused the detailed explanation given at para 3 within brackets small I dash all in small 25 Roman 25 close bracket along with the connected documents. This court is satisfied with the explanation given for the delay of 140 days, is it?
Yes, madam.
On finding that there has been no laches or negligence on the part of the applicant to file the instant appeal against the judgment and order, copy paste. Okay, so accordingly, IA number 126 of 2025 stands allowed and disposed of on the condonation of the delay of so and so days. Yes. Then in the main LA, on the disposal of the IA 126/2025, allowing the condonation of delay, comma, heard Mr. Asil Al-Faqzala, learned counsel for the appellant, who submits that there are sufficient grounds for setting aside the impugned judgment and award dated 17/12/2024, passed by the learned judge, fast track court, Colosseum District in LA case number 15 of 2015, since the learned trial court had failed to appreciate the evidence on record in its proper perspective. Then appeal is admitted. Issue notice to the how many sole respondent now, is it? To the respondent. How many respondents here?
1 and 2.
Respondents number 1 and 2 through registered post with AD within 3 working days, returnable by 3 weeks. So, then this should be listed along with the other cases, isn't it?
Yes, madam.
Because this court. No, here a lot of cases have been listed together again with.
Today, 5 cases are listed on 4 cases, and on 18, 8 cases are listed. Altogether, there are 12 cases taken up by us. Your Lordship has passed an order in 8 cases on 18/11.
Okay, let these two go differently after, at the time of the same. While considering the LA appeal, maybe we'll list them all
Mala,
together.
Mala.
Okay, just leave it. Then what about the next?
The next here, we have filed an affidavit in compliance of justice service on 10/10/25.
Wait, take this away, then the next case that we. Which is this item number?
Item number 26. We have filed an affidavit in compliance of justice service on 10/10/25 against the respondent number 1 to 5. Now, there is an acknowledgement on the notice, my lord, and they have failed to receive the notice, respondent number 1 to 4, and in fact, in respect of respondent number 5, your lordship may kindly see page 18 of the affidavit submitted by us. It was acknowledged by the chairman Zarkot Local Council.
Page 18.
Yes, 18 of my affidavit.
Page 18, here it is said, action, secretary, this is side pi. Where's Zarkot?
In my affidavit stating compliance of justice service, my lord.
Affidavit
In respect
of Dusty. So,
It will be in respect of respondent number 5.
this is 3. Page 18 is 3. So it won't be page 18. You said page 18, is it?
1/8, my lord.
It is page 20, 29 in your.
Maybe I've only paginated. Now,
Vegetation is wrong. Anyways,
here it's written the correct address is not, there is no correct address in respect of the edicant which was returned. Now in the justice service, here the witnesses has written in the notice, Puzora Mona Zarkot, he action of application pek tumpa in filfi na anaya ama Puzora Moy hen hemi case so hen asoidan bangin alo frezaulu tuklo ni na lang hemi lekha dong turati mi dong zong hian an lo sign lo veka ba mi dang zong hian an lo sign lo veka bang hian hemi case tel mi dang ho hi a pe the na anga in sign lo mai a ti thuta ani ti ka shet puye. It was acknowledged by Chairman Zarkot Local Council.
so it appears they don't know about this, what,
No.
about the award, is it?
They knew about the award since the other respondent number 1 to 4 has refused to sign, and Puzora Mona has also failed.
Why have they refused to sign?
I don't know, my lord.
I think they should be explained.
They have been instructed
Not
by
to
their
sign.
council.
Not to sign.
Yeah, like that. Because here we have also mentioned in some of the cases that they have been advised by their council not to sign.
Oh, so it's okay. So they're not going to contest. That means
Yes, my
whatever
lord.
you're
So-
going to pray, it's going to be okay.
Yes,
it
my lord.
appears.
That means this we have complied the notice according to us.
Anyways, again, same order. Okay, it will be have this thing. Refuse to accept, isn't it, in the justice? So make it the same order. Okay. Only thing is, it will be respondents number 1 to 4.
1 to 5.
Okay, 1 to 5 refuse to complete or
Yes.
accept. And then same, then you can say that Mr. Lingui, government advocate, in the previous one also, submits that the state respondents
6 and 7.
should not have been pleaded as respondent number
6 and 7.
6 and 7. Okay, then again, after that, Mr. Alfaguzola said that to strike off, okay, previous. Just add that little line in both. But see the numbers, state is respondent number what? Okay, fine, check down. Yes, then
27.
27, what is the state?
My lord, here in this case.
Okay, wait. In 26, come back. Then in the main, this thing, RFA, notice be issued.
LA appeal.
Okay, in the LA
LA
appeal,
appeal.
connected, same order. Okay. Then they also, we will add, which was not added previously, that Ms. Nal Nunlui submits that the government should not be made the respondent's number. Again, check, okay, in the appeal. Then Mr. Lalfagzwala, same, okay, mistakenly added, names may be struck off, registry to do the needful. Both IA and LA appeal, both that little thing, okay. Yes, now 27.
My lord, in respect of item number 27, a record has returned with the note incomplete address upon respondent number 1.
The correct address.
If we may be allowed to serve Dusty upon the respondent number 1.
Okay, Mr. Asil Al-Fazwala, Learned Counsel for the petitioner is present and submits that since notice upon respondent number 1 could not be served through registered post, he prayed that he may be allowed to serve notice through Dusty mode. Raise aloud. The Learned Counsel for the petitioner is to take necessary steps for service of notice upon respondent number 1 through Dusty mode and affidavit to that effect to be duly filed. Then same, Nal Nunlui, it should not, here state will be 2 and 3. Okay. Then nothing to mention in the appeal, no order in LA appeal here. Okay.
28.
My lord, in respect of item number 28, a record upon respondent number 1 and 2 still awaited. It has not come back.
Okay. We can await, or you want to do Dusty mode?
If we may be allowed to take notice on Dusty.
Same, okay. Only thing is 1 and 2. Respondent. And then same, government advocate will be 3 and 4. Struck off. Here also no order in the LA appeal. IA has to be disposed first. Yes.
Deeply obliged.
Part 2 hearing, item number 13.
Yes. Are you ready?
I am ready, my lord. I'm appearing on behalf of the appellant. However, it appears that the counsel for the respondent is not available
We'll
today.
take some other day. Yes, Miss
Ichlal Rosangi.
Ichlal Rosangi, Learned Counsel for the appellant is present. However, none appeared.
Your Lordship, I'm appearing for the state respondents.
However, none appeared for the private respondent number
1.
While Ms. Nal Nunlui, Learned Government Advocate, for respondent number, for the state respondents is present.
Yes.
Due to the absence of the Learned Counsel for the private respondent number 1, matter is adjourned for
Next
2
week,
weeks.
my lord.
Next
week, my lord.
Okay, next week, let's see. Don't burden me with too many judgments for the vacation. Okay.
Okay, after a week is fine, my lord.
After 1 week. Any other matter?
My lord, with respect to item number 11, I'm for the appellant, but the respondent are absent, my lord.
Okay, today is fixed for hearing again, another fixed matter. Item number
It's not a fixed matter, item number 11.
11. We'll list it after 4 weeks or something. What's this thing? Is there any urgency in the matter?
The respondent are in possession of the land and building.
Even then, Mr. Seed Al-Fagzwala, Learned Counsel for the appellant is present, while none appeared for the respondents. On the prayer made by the Learned Counsel for the appellant, list the matter after 3 weeks.
Due to the absence of the respondent.
Due to the absence of the
I have to mention that.
Yes.